Good morning. Today is Monday, February 10th, 2025. The time is 9:30 a.m. And this is a pre-hearing conference in the matter of James McCall before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We are convening remotely over Zoom, and this pre-hearing conference is being recorded. The Honorable Judith A. Cowin will be the presiding officer over today's pre-hearing conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission. This matter is now before Judge Cowin.
Thank you. Good morning. Good morning, Mr. McCall.
Good morning, Your Honor. How are you today?
I'm well, thank you. Good morning, Ms. Chisholm.
Good morning, Your Honor.
Hello. Okay, and Mr. McCall, you are pro se, am I correct?
Yes, ma'am.
Okay, good. Let's begin by, I'll ask the commission a few questions, and then I'll ask you some questions, Mr. McCall. Then if either of you have anything that you want to discuss in addition, I will give you an opportunity to do so, and then we will proceed to schedule the next hearing. Okay, Ms. Chisholm, I'll ask you first. When do you think you will have an idea of the witnesses that you will be calling?
Well, I'll know for sure when there's a date for the hearing to see, number one, if people are available. Number two, if anyone is unwilling to testify. As we know, with allegations of abusive behavior type cases, there's always the chance that witnesses will not move forward. It's unclear to me how many are willing to move forward. We have interviewed at least one who does appear to be willing to move forward. But if we subpoena people, we will try to put on as many witnesses as we can.
Okay. Now, I have reviewed the protective order that you both, that the division has sent. I assume you sent a copy of it to Mr. McCall, Ms. Chisholm. Okay.
Yes.
Well, what I would like you to do is discuss it with him sometime after this hearing, maybe right out immediately after it, and then notify me by an email sent to Ms. Smith. Notify me when you have discussed it with him, and then I will consider issuing it.
Okay.
Okay.
We have, I can certainly do that. We have not discussed specifically this protective order, but he and I did speak for probably a good 10 to 15 minutes prior to this hearing, say a week ago. It was a productive conversation. We did talk about, if there was a hearing, I was going to be asking the judge if we can use pseudonyms or initials for people, given, the sensitive nature of the topic. Mr. McCall seemed agreeable to that, and I would expect a discussion about the protective order would probably go just as smoothly, but we can report back to you.
That's very good, but I think it's important that both parties understand exactly the limits of the protective order. So a discussion like that would be helpful.
Mm-hmm.
Just so that the parameters of it are clear to both parties. Okay. Now, when do you anticipate, Ms. Chisholm, that you can provide Mr. McCall with the anticipated exhibits?
So I would anticipate providing the discovery, by the end of the week. That would be all inclusive. I don't think I would be introducing every bit of discovery as an exhibit, but I can certainly put some time into thinking about everything that would actually be an exhibit at the hearing, within, a week to 2 weeks.
Okay. I think then I'll ask some questions to Mr. McCall. Mr. McCall, how do we know that you say that the facts were altered from the Snapchat conversation, Snapchat application? How do we know that? Is there a way?
Yes, ma'am. When it was, I know because the thing that was issued to the school department via what the actual conversation that I had that was screenshotted that was sent to my daughter.
Um, did Christy Fisher testify at the internal investigation?
I believe she did speak with now Chief Giannini during the investigation, the IA investigation.
Okay.
Your Honor, every witness listed is someone that spoke personally to, I would say, gave testimony to the internal affairs investigators about their testimony of what occurred. So the investigators have heard this. I do not believe it was recorded. There's an extensive background or investigation that was undertaken in this case. What they said was memorialized in a report, which I believe Mr. McCall has already gotten, as far as the internal affairs investigation and any hearing that might have occurred with that. I do know Mr. McCall resigned at some point during these proceedings. So, but all of these women have gone on record with internal affairs and testified to them.
Thank you. Mr. McCall, you have some screenshots, but I can't open them. What are the screenshots? What do they display, the screenshots?
The screenshot is the actual conversation that was not altered by the alleged victim or witness, I will say, regarding the conversation that I had with my daughter's friend or family friend. Because during the IA investigation, the IA investigator made it seem like, or she told the IA investigator that something transpired that didn't transpire. She stated that she didn't conversate with me. She didn't joke with me. She didn't do anything. So there was like laughing emojis that she crossed out to show that she did laugh. She did speak back to me. And she made it seem like it wasn't like I was just initially what they're making it out that I was preying on her, which that was not the case.
Is there, I'm wondering if there's some way that you can get the screenshots into a form that I can open them and I can see them.
I absolutely can do that, Your Honor.
Okay, and if so, you'd provide them to Ms. Smith at the commission and also to Ms. Chisholm.
Yeah, I believe Ms. Chisholm already have those
Okay,
those things,
Okay.
ma'am.
all right, okay.
Yes, Your Honor, Mr. McCall provided me with I'd say an unredacted screenshot, which is exactly what the stipulated facts are, is the unredacted version. I believe the testimony will be that the juvenile female, when she submitted the screenshot of their conversation, it appears to be redacted, some of it. But what is in the stipulated facts is the unredacted. I believe there's one portion that we're unable to open because it's a photograph. And I believe the photograph, Mr. McCall has said, is a picture of a drive-through, which the captain at Internal Affairs has seen himself and has told us that that is what the picture was. So there's now two people that have seen the picture that agree that it's the same thing. I don't think it's, that's what the picture is, but I don't think we can open that. So everything Mr. McCall is saying is a stipulated fact at this.
Okay, good. Mr. McCall, what witnesses are you planning? Are you planning to call any witnesses besides yourself? Oh, wait, okay, are you planning to call any witnesses?
No, Your Honor.
No, okay. Are you planning to testify if if the commission does not call you?
Yes, ma'am.
Okay, okay. Okay. Now, oh dear. Let me fix that. Well, are you, before we set a date, is there anything that either party wants to ask me? Or say, first I'll ask Ms. Chisholm, is there anything that you want to add?
No, I just, depending on the number of witnesses and whatever date the hearing is, it's difficult to get, 10 witnesses or so available for the same date. If it were to spill over into another date, just based on availability, and also given the sensitive nature of anticipated testimony, we would likely be asking for some of the hearing possibly to be in a closed session, depending on how it plays out and which witnesses are available.
Okay, based on the witness list that you provided me, it seems like a good portion of it might be closed in a closed session.
Yes, I agree. And half of this case involves a juvenile. So that the sensitive nature of that is, exponential compared to everything else as well.
Okay, well, I think that it will be helpful if you and Mr. McCall could work this out with the staff at the commission as far as how much of the hearing is going to have to be closed.
Okay.
Okay, is there anything else that,
Nothing for me.
okay, Mr. McCall, is there anything further that you want to discuss?
No, Your Honor.
Okay, what kind of a date would you be suggesting, Ms. Chisholm, for the actual hearing?
A date, later in March.
Um,
Or early April.
okay. Mr. McCall, do you have any preference, late March, early April?
I have no preference, Your Honor.
Okay. See. Tuesday, April 8th. How does that sound to you, Ms. Chisholm?
That works.
Okay, and Mr. McCall?
That's fine, Your Honor.
Okay, we'll put down the date for the hearing as Tuesday, April 8th. And it started at 9:30. And this will be an in-person hearing at the offices of the Post Commission. This is, now what's going to happen about all your witnesses, Ms. Chisholm? Are you anticipating any difficulties?
I anticipate some difficulties given just the sheer number of them. Again, all of these people have testified to the Fitchburg police. At the very least, I would be asking the investigator to testify to what they told him and make an argument of, indicia of reliability based on using the use of the same language repeatedly to various people, the same tactics, I'd say, gives an indicia of reliability to the women's testimony. So, we will contact the witnesses, let them know the hearing is on the 8th, and bring in as many of them as we can.
Do you anticipate that this would be a 2-day hearing?
I don't anticipate necessarily that the testimony would. It would just be given people's, the sheer numbers availability for one particular date, which I just don't know the answer to that right now. But I think the testimony for each person would probably, it wouldn't be like, the most lengthy testimony for each person.
If I may add, we do have the option for witnesses to testify remotely if that would, provide some flexibility for them. And so you can give them that option as well.
Okay.
Excuse me for that interruption. Well, I think we will have a final pre-hearing conference. And at that time, we could discuss whether we need to reserve a second date for the hearing to continue. But thank you. That's an excellent idea about witnesses testifying remotely if necessary.
Okay.
And if that makes it simpler to proceed, Ms. Chisholm, I have no problem with some witnesses testifying remotely.
Great.
Okay. Well, Mr. McCall, do you have any problem with some witnesses testifying remotely?
I have no issues with that, Your Honor.
Okay. 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 Of course, it's preferable, I'm sure, as both parties agree, for the witnesses to come in person if they can. But if it's difficult for some people, I can understand, particularly since this involves people who probably reside near Fitchburg, which is a ways from Boston. I have no problem with some of the witnesses testifying remotely, but it'd be helpful if at least some of them testify in person.
Okay.
Okay. All right. The date of April 8th for the hearing is agreeable to both parties. Am I correct?
Correct.
Yeah. Okay.
Sure.
So we need to set a date for a final pre-hearing conference. Seems to me that the major, or only major issue right here is actually there are two. One is the availability of the witnesses, and the second is it will be very helpful, and I think it will be necessary, Ms. Chisholm and Mr. McCall, that you all decide just which portions of the testimony have to be in closed session so that we can know in advance and be prepared for that. So with that in mind, let's schedule a final pre-hearing conference. If we're saying that April 8th.
Yeah, Your Honor, I would say if I had to guess, every witness would want their testimony to be in a closed session. It just as a blanket statement. I can't imagine that any of them would want this to be publicly a public display of testimony. So I'll just throw that out there right off the bat.
Well, interesting. Ms. Smith, have we ever had a hearing that's been all closed?
I don't believe so.
Okay.
I'm just trying to think back. Yeah, I don't believe we've had a hearing that's been fully closed.
Okay.
I know that, again, these are two internal affairs cases broken down by different internal affairs numbers. One of them involves the juvenile. The other one involves the allegations of harassment of officers and dispatchers at the department. There is a large degree of the first case involving the juvenile that has been essentially admitted to by Mr. McCall. You have the screenshot of the conversation I believe that could arguably be an open testimony case. I don't even know if the juvenile herself would need to testify, given that this is pretty much admitted based on the screenshot. And she did testify to internal affairs. So that could, arguably be an open case as long as her name is not, spoken.
She can be identified by a pseudonym, her first initials. That's what we've done often in the past. So, Mr. McCall, is that agreeable to you if we can do that? Part of it at least be an open hearing, but the juvenile would be referred to by her initials?
That's fine, Your Honor.
Okay. Ms. Smith, does that seem in line with what we've done in the past?
Yes, it does.
Okay, so I think it's important that the parties get together and decide exactly what can be open and what can be closed. And it looks like most of it's going to be closed, but we need to have that identified in advance. And
Yes.
and you will notify Ms. Smith, and she will notify me which portions will be closed and which portions will be open. And that should be done before our final pre-hearing conference. Okay, so let's say if the hearing is going to be on April 8th, I would put the final conference very late in March, maybe. Well, I know that April 1st is April Fool's Day, but how about Tuesday, April 1st for the, will we need more than a week? Do you need more than a week between the, oh, I'm nervous about that a little. Let's make it March 31st, the final pre-hearing conference. And that can be at 9:30, and that will be remote.
That works. Thank you.
Okay, Mr. McCall, is that fine with you?
Yes, Your Honor, that works with me.
Okay, good. Okay.
I do have a question though.
Yes, go ahead.
With people testifying, I am going to have a chance to cross-examine each and every witness that testifies, correct?
Absolutely.
Okay.
Yes.
Okay.
And then after that, when you're finished with your cross-examination, Ms. Chisholm will have an opportunity to further question the witnesses. And if you want an opportunity to question them once more, it's up to me whether I permit it, but I would generally permit it.
Yes, ma'am. Thank you.
You're welcome. Okay. Oh, Ms. Chisholm, just so we have a date, when would you have the hearing exhibits ready to provide to the respondent?
So I can have the discovery by Friday, and then, let's see. I can have the hearing exhibits if the hearing is, is March 1st or March 3rd, okay? Monday, March 3rd.
Or you'll provide Mr. McCall, with the discovery by February 14th.
Yep.
And you'll provide him with the exhibits by March 7th. Is that agreeable with you, Mr. McCall?
That's fine.
Okay, good. If there are if there are any disputed issues of law or of evidentiary issues that arise, please advise me of them before the final pre-hearing conference.
So there is one, while we're here, Mr. McCall had issued to post-C review and to me a screenshot of a phone. I don't know whose phone that is. I believe Mr. McCall would testify that it's his phone. This is not that Snapchat conversation that we were discussing before with the juvenile. Those are the agreed upon facts. There's an additional one. I'm unable to agree to that as an exhibit, just given that I do not have any way of knowing whose phone that is a picture of, when that phone was taken a picture of. So I know Mr. McCall, he can testify to anything that happened with his own phone, but as far as that actual picture, I'm unable to determine who owns that phone, who took that picture. It's a picture of a phone, but I have no idea whose phone it is. Again, Mr. McCall will likely testify it's his own phone. But as far as a picture of that, I just have no way of authenticating that.
Actually, Your Honor, that picture, it's actually in the IA report. That picture is a picture of my daughter's phone that Chief Giannini did with his IA. So it's in Chief Giannini's it's in the investigator's IA report of where the phone, whose phone that is.
Okay, Ms. Chisholm, can you locate it in the IA report?
I'm just not sure. We might be talking about two different pictures. Mr. McCall, you sent me the picture of the Snapchat conversation from February 14th, 2023, correct?
That's correct.
That's not the one I'm talking about. You had sent it a second one. It has the date of August 9th on it. It has to do with a Facebook friend request.
Oh, yeah.
Okay. So that's
Okay.
the one that I agree. The one you're talking about, internal affairs from February 14th, Snapchat conversation with the juvenile. I agree. I would not object to that being put into evidence. It's the second one that seems to be a subsequent event that you sent me a picture of, and I believe you submitted it to the commission.
That is correct.
That is something I can't agree to put in as an agreed upon exhibit. I would object to that being put in as an exhibit. And I'm just bringing it up now just because, to avoid having to just meet prior to the final pre-hearing conference when I already know that that's something I would object to.
Okay, Mr. McCall,
Yes, Your Honor.
what do you say to that?
Well, I believe that it should be allowed. Like I said, for the reason is because she sent a friend request months after to me on my social media, months after the incident transpired, months after I had already resigned, terminated and then resigned, which goes to show that she is not as much of a victim as they're claiming that she says that she was, or that the police department or that the commission is claiming that she is. Because if that was the case, why would she send me a friend request even after all of this? I didn't send her a friend request. She sent me a friend request. So I believe that item should be used.
This is a friend request?
Yeah, a friend request on Facebook.
So, like I said, I would not object to his own testimony about it. I object to a photograph of somebody's phone. I don't know whose phone it is. I don't know when it was sent. Like, I just can't agree to a photograph of something that I can't authenticate. Again, Mr. McCall certainly can testify. I would object on the relevance of something happening. I don't even know when this happened, because again, it's a screenshot of a phone, but I would object to the relevance of what happened possibly a year later.
Okay, Mr. McCall, do you have any way of establishing this to Ms. Chisholm's satisfaction?
The only thing that I have, Your Honor, is that actual photo. Like I said, when I received the friend request, it has the date on it. It has actually a picture of my dog on it. It has my girlfriend's a text message from my girlfriend on it. And when I received it, I initially hit the screenshot button and I saved the photograph. That's the only way that I can authenticate it. But it did come from my phone.
Is there, I'm not all that, I can use the iPhone, but I'm not all that familiar with things like saving and Snapchat and all that. Is there any way that it can be identified that it came from your phone, Mr. McCall? Of identifying it as coming from your phone?
Other than the pictures in the background, there's no way to actually identify it.
And the pictures in the background, you say, are of your dog?
Yes, ma'am. I believe it's of my dog.
Of course, your dog could be near anybody else's phone. So, I'm trying to think. Ms. Chisholm, can you think of any way of authenticating it?
You know, I can't, because it's just a photograph of a cell phone. You know, that, again, Mr. McCall could testify to his experience, but and whether that's deemed credible or not, but that cell phone could be anybody's cell phone. You know, like, I have no way of agreeing to a picture of a phone. And I would also argue it's not relevant, because I do believe Mr. McCall is going to testify that it came a year after this incident. You know, what we're here for is the incident that was investigated that he resigned for. So what he's going to testify about happening a year later after being off the job for a year, I would argue is not relevant. But a screenshot of a phone that I can't determine when the screenshot was taken beyond, I believe the date on it is August 9th. I can't agree to that being proof of what he would testify to. And I would ask that not be admitted into evidence. Problem is, it's already been sent to the commission. So I would just ask, like, any, I would just ask that all of this type of evidence not be sent to the commission. I think it's premature, and I understand Mr. McCall represents himself. So stuff like this is going to happen naturally, but.
Well, let's think about it. If it were a regular phone call, a landline, it would only be authenticated by someone saying, you know, well, you'd hear the voice, you'd hear somebody else's voice. Well, let's think about a regular photograph. Somebody would say, this is a picture that I took. And he's saying, this is a picture that I took on my phone.
Right, but it could be a picture of somebody else's phone. Like, there's just no way of knowing. Like, I would suggest he's going to testify that he received a friend request from the juvenile on his phone, and here's proof of it. But that could be a picture from anybody's phone. She could have friend requested anybody else. And I would also argue to the, the relevancy of something happening a year later. We're talking about conduct that occurred on February 14th, 2023. And I believe the testimony would be to something happening in possibly a year later. Again, I don't have any.
I don't have a problem with the relevance. I mean, you can argue that your argument would go to the weight, not to the admissibility of it. Given what he is offering it for, I think that if you can argue that the fact that it's a year later makes it less relevant, the same arguments you presented to me just now, but I don't think that that renders it inadmissible. I'm having more difficulty with the question of identifying whose phone it was from. How do you identify anything from anybody's phone, Ms. Chisholm?
Well, in this case, Mr. McCall in writing stipulated that that was the Snapchat conversation. So in this case, I don't believe I need to prove what phone is what and who sent what. It's all been admitted to, not only in the stipulated facts, but in the internal affairs case.
So what's the difference with this picture, conversation, whatever it is?
Because the juvenile has never told anyone whether she sent a friend request to Mr. McCall a year later. That's not part of this investigation. So the other side is not admitting to that. It's not a stipulated fact.
Is the juvenile going to testify at the hearing?
The division does not believe it's going to subpoena her to testify, given the fact that this is all admitted behavior. And she's testified to internal affairs. And I believe the captain who she testified with can testify to her demeanor during her testimony, if that's of any relevance. I would also argue that the juvenile's reaction to any of this is not an issue. It's Mr. McCall as a police officer's behavior. Admitted behavior is the issue.
All right. All right, I'll think about this and we can talk about it again at the final pre-hearing conference. If there's any way of resolving it, of course, that's helpful. If not, I'll make a decision either at the pre-hearing conference, or I may hold off making a decision until the actual hearing. When I hear the evidence, I might be in a better position to rule on it. But I appreciate you bringing it up now, Ms. Chisholm. These are the kinds of things that I would do want brought up ahead of time and should be. Now, are there any other anticipated evidentiary issues or confidentiality issues? We've discussed the confidentiality, I think.
No, I don't believe so.
Okay.
Not on my end, Your Honor.
Okay, good. Okay, if you have, excuse me, additional agreed upon statements of fact, I'd like that in writing. Let's see. Before the final pre-hearing conference, so we could say if there are additional stipulations of fact. Oh dear, what's that? let's say March 24th. In fact, in fact, March 24th, I'd like a final pre-hearing conference memo from both parties to be submitted by March 24th at the end of the day. And that would include any additional agreed upon statements of fact.
Yes.
Okay.
Okay. Okay. Are there any other matters that either party feels need to be discussed? Oh, dear.
No,
No,
Your
I don't have any at this time.
Okay, good. Then we will meet again on, for the final pre-hearing conference on March 31st at 9:30. And we will anticipate the hearing being on April 8th at 9:30. Good, thank you both.
Thank you.
Thank you, Your Honor.
Thank
Just
you.
one thing before the parties go.
sorry.
Oh,
Yes.
no, I just want to remind the parties that as they consider, what portions of the hearing should be closed, to please refer to 555 CMR 1.10 subsection 4A2. And that specifically talks about closing the hearing. So, when making that case, just please refer to that section.
Yes. And Mr. McCall and I will discuss the protective order. Your Honor, you'd like me to go through it kind of paragraph by paragraph to make it clear to him, like, if you were to sign that, this is what would be expected of the parties.
Exactly, thank you. Ms. Smith, why don't you give us the citation of that section again so that both parties can have it?
Sure. It's 555 CMR 1.10 subsection 4A2.
Okay, it's 555 CMR 1.10, section 4, subsection A2.
Yes.
Okay, so, okay. Do you have that section, Mr. McCall?
I do, Your Honor. Thank you.
Okay, so that'll be helpful if you review that. All right, thank you, Ms. Smith. Okay, then I will see you again, excuse me, on March 31st at 9:30. Thank you both, you've been helpful.
Thank you, Your
Thank you.
Honor.
Thank you.